One of the most important parts of the practice of law, and it's become quite large over the last 20, 30 years when I've been practicing, is called motion practice. You pretty much get everything done that you want inside a case in the way you file motions, and it's called your motion practice. I remember in law school, second day of a class called Civil Procedure, the professor reminded us that pleadings are not motions. It didn't mean a thing to me then. It barely meant a thing to me once I started practicing, but then I started to get it. Pleadings are the lawsuit, and our motions are what we use to effectuate, to bring the lawsuit to its conclusion. So that's motion practice. I hope I didn't make that more complicated. But a motion is just a formal way of asking the court to do something for you. And it's just your way of saying, hey, he's not doing this, or she's doing too much of that, or she's not doing any of it at all and I needed more of it done. You can actually say anything you want in a motion. You can move for anything that you want. So, and it sounds like how could you do it in the practice of law? Because as long as you can support what you want, courts will listen. That doesn't mean you're always going to win, but courts will listen. You just got to move for the thing you want. So motions can request many things: dismiss a case, compel discovery, file a response, or a counter motion to a summary judgment, or even simple stuff like, hey, I need a better date, or hey, can we have a settlement conference? You can move for anything. And it actually makes it easy if the other side agrees with you. So they are very intense rule supporters, meaning this is an area, motion practice is basically generated by the rules. It's probably the closest that an action and the rules come. You know, you can be in a courtroom and a trial and you can kind of gray area your way around things. But when you're filing a motion, you got to be married to the court rules.